Federalist Society, the George Mason chapter, and thank you all very much for coming this afternoon. Richard A. Epstein is the James Parker Hall Distinguished Service Professor of Law at the University of the greatest thought since 1972. He has also been the Mary Christian Bedford Senior Fellow at the Hoover Institute since 2000. He served as editor of the Journal of Legal Studies from 1981 to 1991, and of the Journal of Law and Economics from 1991 to 2001. At present, he is the director of the John M. Olin Program in Law and Economics and on the board of advisors of our very own Journal of Law, Economics, and Policy.
This I did not know.
These books include Skepticism and Freedom, A Modern Case for Classical Liberty, Cases and Materials and Torts, which, for those of you like Professor Krauss, should remember.
Only section that uses it? Ooh.
Principles for a Free Society, Reconciling Individual Liberty with the Common Good, Simple Rules for a Complex World, and most importantly to our discussion today, Takings, Private Property and the Power of Eminent Domain, which was made notable by Senator Biden during Justice Thomas's confirmation hearing. Professor Epstein has written numerous articles on a wide range of legal and interdisciplinary subjects. He also wrote an amicus curiae brief for the Kelo Institute on behalf of Suzette Kelo and her fellow tenants to fight the eviction notice that the City of London issued to go forward with a, quote, so-called redevelopment project which will accomplish, at most, nothing. Without further ado, on behalf of the George Mason chapter of the Federalist Society, it is my privilege to present our speaker, Professor Richard Epstein.
Well, that last in a reference brief, and you saw just how much good that it did. Where to pick this up? But actually, I have an enduring debt to the George Mason Law School. In all the articles that I've ever written anywhere, I've never had a citation which says one journal at one. Anything I wrote, until I wrote a piece on the sort of law and economics of self-help, which came out in that review, I guess it was in 2005. And I don't think I'm likely to have this again, but it was nice, and so I have an affection for this place above and beyond all credit to reason. In terms of the other thing, let me just mention this mysterious reference to Justice Scott, to Senator Biden on the Takings book. Some of you will not be old enough to remember Clarence Thomas in 1991, but in fact, before we got to the sex stuff, there was a learned debate as to the extent to which our beliefs in constitutional law ought to be informed by principles of natural law and natural justice. And what happened is Senator Biden, who is this notable expert on constitutional law, whipped out of his back copy a paperback edition, I wish you could find it, of my Takings book, held it up before a somewhat puzzled Mr. Thomas, and announced that anybody who believed any of the principles contained herein is not fit for service on the United States Supreme Court. Which in his view, I think, was surely correct. But somehow or other, Senator Biden, as an intellect, has not survived. The Takings book, thank you, has done reasonably well. And I like to say about it as a kind of an entree into this discussion. Whenever you write a book, it is really devastating if it is refuted only one time. Because chances are that means that the critic has got it right and the author's got it wrong. But when you've been refuted 20 times by different critics, you have to treat that, as I do, as a genuine compliment. Because what the 20th critic is saying is that the other 19 haven't done it right. And what I'm saying is you've done no better than your previous stuff. So this is essentially the framework in which I've worked. I've devoted my academic life to it. Let me just set the stage for this discussion about Kelo in two ways. One, I will talk a little bit about the framework. And then secondly, what I will try to do is to talk a little bit about the case and how the two things come together. And the first thing to note about the Takings Clause is that it is a profoundly anti-libertarian doctrine. What doctrine? It says, nor shall private property be taken for public use without just compensation. It does not say, nor shall private property be taken for public use without the consent of its owner, which is another formulation. A good libertarian sees no place for forced exchanges and thinks that the only time that you can exert coercion against another individual is in those cases where he commits or threatens a wrong against you, and that's the forced case. Or in those circumstances where he's made a promise to you which he chooses not to keep, which is the contract case. The forced exchange, which is an absolute essential portion of the common law, means that somebody is allowed to impose coercion against somebody else who's not a wrongdoer. And worst of all, he's allowed to do so for the benefit of the other party. So if you're a very hardline libertarian, you have to conclude that the takings clause is something of an intellectual mistake. On the other hand, the takings clause does have at least one virtue. It is profoundly anti-redistributivist, which means that not only do you offend the libertarians when you adopt it, but you also defend the modern American left, who thinks that the whole function of politics is to take from A and to give to B, where A is in fact your enemy and B turns out to be your friend. Both will be identified later only through the clash of democratic politics. And to the extent that you have a rule which says that the taking will take place only if just compensation is provided to the person from whom the property is taken, what you've done in effect is to place a minimum boundary condition on how much you can exact from the particular person in question. So that you have to be able to get the resources from taxation or from some other public funds, which are very hard to come by, in order to take from this guy. So there's now a systematic incentive on the part of the state not to take property which is worth 8 when it's in public hands, if it's going to cost them 12 to get it because it's worth more to the private owner under some market value or other system of evaluation for just compensation. Now, if you put these two halves together, in which, in fact, what you do is you allow the state to take, but you don't allow it to take for general redistributive purposes, you have yourself, in effect, a very moderate position. Why should you like that position? Well, with respect to the first half of this situation, the reason you have to take, and the only time that it makes sense to take, are in those circumstances where the taking involved gets you a result which you could not achieve through voluntary cooperation amongst the various parties. And if you go back to your first year classes and you start to think of the instances of market failure, what typically they happen to be are those cases in which one individual has a blockade over everybody else. He owns the crossroad, and without his consent, nobody can go either north-south or east-west. Or there are so many people who have so many fragmented interests that unless you can combine them through coercion, a series of non-cooperative threats means that the joint venture will never take place. And a real-life instance of that is you have a large oil field which is on top of private farms which are much smaller scale. And if it turns out that you don't have a way in which to stop the drilling, each of the surface owners will so overconsume resources that in the end nothing will come out of the common field. And what the takings clause allows the state to do is to charge a fee to administer the system, and then in effect to make sure that you have only that number of wells which optimally pulls the fluid out of the ground and divides the proceeds pro rata, so that everybody surrenders his right to drill, which is what is taken, and receives in exchange a larger fraction of a larger pond, which is what you get by virtue of the efficiencies that you create. So essentially, the answer to the hardline libertarian is that if we have a test of Pareto formality, one which says that we want to make people better off and not worse off, you can, in effect, if you design your takings clause correctly, get to a Pareto superior position with the use of coercion that you could not get through voluntary means. And then on the other hand, it turns out that if you look at the redistribution side, what you immediately realize is that if you can stop the redistribution, you will stop the competitive activities whereby people will go to the state and hope to get something which other people will pay for, because redistributive gains are always negative sum. So essentially, if you come to George Mason, the home of public choice, what you would say is that the intermediate position that the takings clause occupies between the full-breaded redistributive state on the one hand and the pure libertarian holdout state on the other is in fact the right place you want to be. Now, when I wrote this little takings book, not only did I talk about these two issues, which I think in the end still make sense, but there is another problem, which is a happier problem, which you also have to worry about. Many times when you make a taking from one person to another, what you do is you do produce positive sum gain. So people who are worse are better off. The question often then arises as to how it is that you distribute the surplus that has been obtained by collective action. And one way to understand the public use requirement in the Constitution is as a way of saying that when you take this thing and you put it to public use, you'd like, to the extent that human institutions can arrange it, to divide that gain evenly amongst all citizens of the state. Because if you can stabilize the gain in terms of its distribution, you stop a second fight over the dissipation of surplus, where everybody wants to claim more than they would otherwise be the case. And so if you have a situation in which everyone can play 2 and everyone can get 10, that's a huge gain. But there's going to be a tendency for one person to say, maybe I'll pay nothing and somebody else will pay 4. And you'll constantly then battle between whether or not your surplus is 6 or 10. And you could waste resources in the allocation of gain that you could not do if you stabilize it. So one of the things that you now quickly understand about this whole crazy world is that to the extent that you can devise pro rata distributions, they stabilize gain in a way which in effect allows the use of coercion to generate more positive benefits for a society than you could have if the state could freely arbitrate the gain amongst individuals in any way, shape, and form that it seems to be possible. Now, within this framework, how do we then understand the public use requirement, which is a formal limitation on the kinds of situations in which gains can take place? And the simplest and the most obvious explanation for why it is that we want this particular provision to be here is if, in fact, we allow takings from A to go for the benefit of B and only for B, what happens is that certain individuals are going to be able to get the power of the state. They may, in effect, pay just compensation at the minimum level to the other fellow, but they'll incur, or at least they will create a situation in which they'll be able to keep the lion's share of the gain for themselves, and will therefore create a set of factional intrigues in the world of gain, which can only reduce the size in question. If you can limit the kinds of objects for which the state can take property to those which in fact have generalized public non-exclusive benefits, you will in effect limit that particular power, and by so doing, will be able to handle the central problem of political theory, how it is that you limit the coercive powers of the state that you must create. Now, how does this then cash itself out in terms of particular cases? And here, if one goes to the pre-modern, pre-New Deal stage, it essentially means that you get 3 kinds of cases for which some sort of takings are allowed, 2 of which map in pretty well to the language of public use, and the third which does not. The first of these kinds of cases is the situation in which, in fact, you just take the property and you put it, in the most naive sense of the word, to public use. So what we do, in effect, is we take the property and we build a public road, which is open access with respect to everybody. Will the Constitution therefore guarantee that you build only efficient roads? The answer is, of course not. Because any road will do, and you still always have the worry about whether construction companies or landowners are going to position the road or inflate the cost in ways that will create some kind of abuse. So you can say about the public use requirement that it solves all your problems, or you can say is that it limits the kind of cases in which these forms of misallocation takes place, and does so for a perfectly good reason. If you don't have a set of public roads, it's going to be extremely difficult to figure out how it is that you get communication and transportation back and forth across a large and complicated society. So the gamble is we will take the risk of various forms of abuse in terms of the process of assembly of land and construction in order to make sure that we can have a neural network for a civilized society. And indeed, whenever you talk to serious business government types, they never worry about the zero state. What they're always worried about is how it is that when you do use the power, you actually use it to construct sensible infrastructure rather than creating these kinds of pointless bridges for nowhere, all which meet this constitutional requirement. Now, the second form of case is slightly different from the first, and it requires you to pay a little bit of attention to the use of the word use in the phrase public use. And the classic case of which this happens is as follows. It's a situation where you take land and you give it to a private railroad which operates as a common carrier. Now, the definition of a common carrier is somebody who has to take all individuals at reasonable and non-discriminatory prices. And the reason why they have to take them in traditional terms is it was the only railroad in town. And if they have a monopoly position, they could either extort everybody or play favorites. And so this RAND, reasonable and non-discriminatory conditions, are an effort to constrain monopoly power. But if you in fact were to say that the moment you want to condemn land for a railroad, only a government can operate, what you do is you condemn yourself to the worst forms of inefficiency. You make all the world into Amtrak, which is hardly the way in which you will improve overall resources. So the traditional doctrines were very clear that so long as the public had use of the product as a common carrier, the public use requirement was satisfied, even if you were charging fees, because the correlative was that the fees that you were charging were to be set and regulated in ways that avoided the kinds of abuse that we talked about with government power. Again, this is a most imperfect enterprise, but at least through large portions of the 19th century, people were doing better than random in an effort to satisfy these two conditions. I don't want to talk about that further. The third class of cases is one which goes back to the original holdout problem, but doesn't involve a public party. And in these particular cases, it seems quite clear that the theory that we're talking about, figuring out how to make a fair allocation of gain when there are genuine holdout problems, doesn't comport exactly with the constitutional checks. The hardline libertarians tend to be very suspicious of this line of cases, and the more pragmatic classical liberals tend to be more sympathetic to it. I put myself into the second camp. And so the problem arises, I own a mine at the top of a mountain, and the only way in which I can get stuff out of this mountain to some railroad track is to cross over the scrubland of another individual with a tram which doesn't even cut the ground. If in fact you use market processes, the blockades are so strong that the mining may never take place, and in fact if it does, there will be what we call a genuine extortionate problem, as this one guy who contributes resources of almost no value gets an equal share of the gain with the other fellow. This is the constant situation where you must assemble A plus B. The bargaining game is indeterminate, notwithstanding the very difference in cost that it takes the two pieces together. So the older Supreme Court cases, when faced with this, said, look, here is a real problem. And when you have these peculiar physical circumstances, and there's an absolute necessity to run this kind of transaction, we will call this a taking for public use. And there are a bunch of cases starting in the 1860s going consistently through the period about 1910, in which the Supreme Court, with a little bit of uneasiness, because of the technique, because of the tension between the pragmatic need and the textual prohibition, lets this stuff go through with a kind of general sake and say, this far and no further. Now, when you get to the Kelo case, if that's as far as you go, you don't go very far in Kelo. But in fact, before we get to Kelo, we should now also understand that there is another kind, or another strand of public use doctrine, which does not take its key from classical liberal philosophy that is worried about how you justify the use of government power. Rather, it takes its key from the progressive movement, in which what you do is essentially regard every piece of constitutional prohibition on state power, whether in the form of federalism on the one hand, or an individual rights on the other, as a useless encumbrance which prevents the exercise of collective administrative expertise done through the larger and more empowered state. And so what the great constitutional agenda between 1900 and 1940 of the American progressive movement was to dismantle all of these prohibitions. And they did, by and large, a pretty good job of wrecking the system under this kind of a world view. And so, starting in the 1930s, there are a bunch of decisions which say that public housing projects are, in fact, takings for public use. Even if it turns out that what you do is you knock down a private home, put up something else which is a private home, and you give tenants ordinary leases on their property. And you announce that there's some indirect kind of public benefit which is attached to all of this stuff, which insulates it from constitutional scrutiny. In 1954, at the federal level, there's a case called Berman and Parker. Somebody has the bright idea they want to clean up, was it Southeast Washington, I think, which is a complete grunge portion of the world then and now. Shows you how successful the campaign was. And so the only way to clean up the city, of course, under Justice Douglas, is to approve some sort of comprehensive plan. And the only way you're going to get a comprehensive plan worth its salt is to knock down the one building in town that actually is making money, because it stands as a reminder of all the failed policies which took place in previous ages. So when they had Mr. Berman, or maybe it was Mr. Parker, they wanted to knock down his department store, Justice Douglas wrote one of these opinions which said, you know, public use means anything that the public thinks is going to work in favor of its benefit, and beautification will qualify, as well as the elimination of blight. And so what happens, therefore, is essentially his position is, you give me an urban renewal plan and I will give you its blessing. Please do not worry about any constitutional limitations. Even if it turns out that after this house is knocked down, or this apartment store is knocked down, rather, we're going to turn it over to some other private developer. And so what you do is you get these transfer situations. And in fact, one of the things that we know about the history is the moment that you allow this, the condition of these buildings is no longer an exogenous feature. One of the things that I discovered when I was speaking about the Kelo case before it came down is that a number of people who had been affected by various sorts of public condemnations for private developers said this is the pattern. First, what they do is they cut off all the municipal services. That drives down the value of their property, then they condemn it. Once you're gone, then they put in the infrastructure in order to help you develop, right? Real sweet. But these kinds of patterns, in fact, do take place precisely because the degrees of freedom that you have when there's no public use limitation on this means that you will find that a city will screw up its entire system of the distribution of public services in order to reduce its condemnation bill and to drive out owners. If this were a landlord doing this to ordinary tenants by cutting off the heat, we would call it constructive eviction. But if we talk about it in the public context, since Felix Frankfurt is good people never make a mistake, we call this intelligent social planning. Now the last stage in terms of the recent cases, before you got to Kelo, was an important and misguided case called Midkiff against the Hawaiian Housing Authority. And what happened in Hawaii was that there was a huge run-up in prices in the late 1970s and early 1980s because there was now a very strong interest on the part of many Japanese to buy property on the island, which meant that you had a huge, at that time, seemingly exhaustive source of demand. And many of these properties in question were owned by the bishop's estate. And the bishop was just the husband of the Kamehameha, so what you're really talking about is after the Great Mahili, that is the property divisions that took place in Hawaii in the 1840s and 1850s, these were owned by the Crown family. And they were let out on leases. And the leases, in effect, had moderate terms to go, and then there was a reversion. And so what the state legislature said is, we would rather have the individual tenants who have 4 years on a lease, or 10 years on a lease, sell to the Japanese, than have the bishop estate do this. So they passed the statute which said, if you, the tenant in possession, put, I might add, the wrong sum of money, too little, into an escrow account, we will condemn the property from the landlord's interest, pay him the money that you put into escrow, and transfer the money, the property over to you, right? And so this is essentially, basically, the state condemns the reversion from A and turns out to give it to B. And so one would have said, this looks as though it's taken for a private use. But Larry Tribe and Kathleen Sullivan on a very imagined constitutional day. So this is perfectly okay because it's a way to counteract oligopoly. And that's just like fighting blight back in Berman Park. If you announce the word oligopoly, wave a flag, it's an oligopoly. So now there's an indirect public benefit in this case, which is breaking up General Motors, and so you can do this one as well. And Sandra Day O'Connor, who I think lived to rue the day that she wrote this opinion, at least I hope she did, said that, you know why this case works that way? Because if there's any conceivable indirect benefit, it means you satisfy the public use requirement. And the word conceivable is not my word, it's her word. Do a little bit of public choice and ask yourself how many programs get through from which nobody benefits. And if you go to George Mason, you know that that's an empty set. So the moment you find that there's one winner, there's a conceivable government benefit, so therefore all programs that can pass the legislature meet this particular result. And then it's just a question of turning over enough eggshells to figure out under which one of them you can actually find a live egg. But sooner or later you'll find somebody who benefits, and in this case you got the whole tenant class, and so you allow them to do it. Fortunately, the market crashed after this happened, and so all these gains were actually never obtained. It's interesting what the history was. But she gives this, and then you get to the Kelo case. And it's only a charming history that only a law professor could love. I mean, this case, if you speak to any responsible planner of the good, virtuous, big government variety, they will tell you that the facts of the case are a public disgrace. From my point of view, since I'm not a particularly strong on the planning tradition, I regard it as not a disgrace, but as an abomination. But anyway, what happens is you have the fair town of New London, Connecticut, which is down on its luck. And after you see the way they handled the Kelo problem, you know exactly why they're down on their luck. Because they've been ruled by a bunch of buffoons and nitwits for all too many months. I mean, they just simply don't know how to run a town. And they're constantly losing business to people out in the suburbs and nearby towns who know how to play the game a little bit better than they do. And this is a typical form of competition in which they're the dead losers. And so what happens is they decide that they have to engage in revitalization. And since they're corporatist in their mentality and grandiose in their aspirations, they put together this plan which makes absolutely no sense. And what they say is, we've got about 90 acres of land which we own from the various government projects that have been disbanded in our fair community, and we can build all sorts of elaborate, stuffy buildings that nobody will utilize on this space without condemning any additional property. And so we can build a hotel for which there is no market, an office building for which there is no market, all sorts of things for which there is no market. Why? Because poor Pfizer had actually built a research facility nearby, and they were convinced that they had them as a captive, and when they put all this other stuff, everybody who wanted to be near Pfizer would want to be in New London. They did not realize that there was an invention of some earlier date known as an automobile, which allowed people inside New London to go to hotels that were located in nearby towns, or to find office buildings elsewhere. And as they were diddling around with this particular project, everybody else who saw the Pfizer plant there as a potential source of markets started to build up. And these guys who were tied up with government projects, of course, did nothing except negotiate contracts and build infrastructure without worrying about, hey, do we have any money to pay for structures? A small detail. Now, in the midst of all of this stuff, with the 90 acres they own, I know this sounds exaggerated, but I think it's pretty accurate. There are about 13 or 15 or 20 houses, some of which are on the periphery, some of them a little bit closer to the center, which occupy about 2 acres. And these guys say, if we don't know how to plan for 90 acres, well, we don't know how to plan for 92. Let's just condemn these houses, rip them down, and we'll use them for something, which we will figure out someday. So when the case actually goes into litigation, it turns out the Institute for Justice, which really brought this case, keeps crossing-examining the public officials and says, what public purpose do you want to put it to? And if you were thinking back to the holdout problems, they would say, we have to put up this huge plant, and unless we have these houses, we can't build anything. No, they don't say that. They say, this is for park support purposes. We say, where's the park? What's the support? Where's the, oh, no, we can't do that. You know, these are lands that we really have to have for park support purposes. It goes to the trial court in Connecticut, which is highly socialist in its ambitions, taking the federal view on this subject. And this judge says, look, the houses that are on the periphery, we're going to prohibit that taking because we can't figure out why they're doing it. Those that are located closer to the center, we'll let them take. So he split the baby. You would have thought that the fathers of New London would have said, enough, and just acquiesced and gone on. But there are appeals. IJ appeals for the people in the middle, and the city. And sure enough, they get to the Connecticut Supreme Court, and the Supreme Court says, you know, all this land is contiguous. The town tells us it's one single comprehensive plan. We don't understand the first thing about planning, and they prove that in their opinion. And so therefore, we're going to allow this whole thing to go through. No questions asked. Now this was in fact a great catastrophe for the planning board. What they should have done was to have accepted the split verdict, but they didn't. And so then the Institute people, actually having lost the whole case, they went to the Supreme Court, and much to everybody's amazement, they took certiorari on the public usage. The battle that I had with the IJ people was whether or not you use only the narrow account of public use and exclude all the necessity cases, or the broader account, include the necessity cases, and then say, looking at the facts of this one, it isn't there. And I argued one way, and I think in the end the IJ actually came around to the same position because they knew that the cases were against them. And they did, I think, a very good job in trying to expose the aridity and stupidity of this opinion, but they did not deal with the invincible ignorance of one Justice John Paul Stevens. And his basic view about this subject was he was a bound slave, that there was nothing whatever he could do in order to stop a program, and so therefore he reluctantly let it go through. Or so he said when he spoke in Las Vegas. If you read this opinion, and in fact if you read all the other land use opinions of Justice Stevens, what you will discover there is no longer a government program that you can find that he does not want. And in fact, over and over again, when he's dealing with the just compensation issue, with the zoning issue, his constant refrain is, if we make planners pay money, they might might not be able to plan as much as they would otherwise do. He never asked the second question as to whether that's a good or a bad thing. And in fact, he doesn't know how to answer the second question because his own legal education took place at a time at which all political decisions had only distributional consequences, and none of them had allocated consequences which made people better or worse off. So if we got the right distribution, what's there to worry about? I mean, that's basically the progressive mindset. That's basically the set that he comes out. And then what he does is he says, yes, we could uphold it 5-4. The interesting feature about this case is afterwards, when in fact the ruckus comes up to the point where the outcry is crazy, he says, I was absolutely bound to do it. I had no choice. I was required. And he becomes a man who, instead of being a social planner, is now Blackstone's judge who only finds the law rather than making it up as he goes along. Unfortunately, it's just not true. And here you go to one of the sort of funny ambiguities associated with constitutional law. I've already indicated to you that in dealing with the word public use, it doesn't quite capture how you deal with these bilateral monopoly necessity cases. The other thing about public use, which is not really caught in the words, is this simple question. Does it make a difference when you're applying the test as to the kind of land that you're actually condemning? And, you know, so somebody who doesn't know very much, you would think that the state would have to have a stronger showing before it condemned a religious shrine or a cemetery, and a private home over an ordinary business, and a business over a junkyard, and a junkyard over a place of vacant land. The basic intuition that all of us have is the more distinctive and unique the subjective value associated with a particular property, the greater reluctance you ought to have in forcing an owner to take market value for things that they treasure. And of course, you know, the IJ wrote exactly the right brief on this point when they said Miss Kelo has lived her entire life here. She doesn't want to move anywhere else. She's not asking for more money. She's not trying to bargain. All she wants them to do is to go away so that she can die in peace in the home in which she was born. Which is essentially saying subjective value is very hard. But it's better when she says it than when I say it. There's a certain leveling quality about economic discourse which you have to avoid if you want to be a good lawyer. So all of that turns out to be true. And so all you have to say to Justice Stevens is we understand they're oligopoly cases. And the last thing we want to do is to describe our friend, Miss Kelo, as an oligopolist. Right? I mean, it doesn't strike us as though she's the royal descendant of the Hawaiian king. She's a nurse, for God's sake. And then, on the other hand, there's blight, but nobody claims that these houses are blighted, although when you give a planner an option, you will now find out in California what the definition of blight is, and I kid you not. It's having leaves that are not swept off your tennis court. That makes you into a blighted community today. It justifies the taking on the grounds that we are dealing with the Berman and Parker law. But they didn't raise that question. So if you went back to Midkiff, you could say this doesn't fall within the oligopoly cases. It doesn't fall, therefore, within the blight cases. So all it is a taking from A to B, where we don't even know what's going to be going on in this case. And you could have decided the case the other way and have left open the question of what you do on the question of when the land is needed for assembly for a project that you can't put up a Kmart or whatever it is, where you have to have every square foot for land, for parking, for housing, otherwise it doesn't go. But they didn't want to do that because the planners simply did not want to back off in a brief and say there was any limit whatsoever that you could identify. And over when you debate this case, you keep asking a planner. The public use language is in the Constitution. It's got to stop at least some transaction somewhere. Tell me one that it stops. And the only thing they can come up with in cases of absolute corruption, in which they're bribes of public officials. And it seems pretty clearly that the term's a little bit broader than that. So give us a case in which they're not being bribed, in which they're not doing it for public use. And they can't come up with an answer. They won't give you a case which suggests they're not being very serious about the venture. Now, when this thing comes to the public, it has very little to do, for the most part, with the fineness of the bilateral monopoly and the necessity case. It essentially has to do with the public perception. You don't throw people out of their homes unless you have a very strong reason for doing so. And that's completely different from the sort of rational basis, any conceivable purpose. And all of a sudden, everything starts to simultaneously explode in the face of the United States Supreme Court. The polls on this issue are about 90 to 10. And the 10 were all planners and their immediate relatives. It's not as though it's a real sort of bias And you start seeing this huge frenzy of action that takes place as state legislatures, state constitutional committees, federal legislatures are doing all sorts of things. In the end, the buzzword that seems to be carrying the day and may well prevail is we do not allow takings by government agencies for private economic development only. And the one sentence that really grabbed people was not my abstract theoretical stuff, that never wins in public. It was the line that Justice O'Connor said, can you condemn out the Motel 6 to put up the Ritz? Can you condemn out the Hubble to put up the mansion? And it's strange that what happens here is that the libertarians and the populists all of a sudden come together. Because what happens is the libertarians care about property rights, they care about process, they care about the dissipation of surplus, and the populists don't like developers, right? And they are perceived as being the Svengalis who are behind the screens, pulling all the strings. Now what has happened? In view of this thing, the populist sentiment has carried much more clout than my libertarian arguments. I'm surprised, no. Disappointed, no. But slightly wistful about the fact this is the way in which political stuff goes. And here's the first effect that we discovered, is that when people actually look around, developers don't want to do these takings that look like they're takings for privilege, even if there are no constitutional or legal impediments in the jurisdictions in which they act. So that the total volume of cases has gone down, because once the political awareness has been raised, it turns out that the price is a lot higher. And all sorts of people have to prove these things inside the political process to change their views. So this is a case in which, having lost the case, it seems pretty clear that the volume of takings that's likely to take place, at least in the short run, is going to be down because of the greater public awareness that takes place on the issue. How much, it's very hard to say. The second thing is you start having all sorts of committees getting together to try to figure out what to do about this at various levels. And I think at one time in the summer, in the early fall of 2005, I must have been contacted by 8 or 10 different state legislatures for either appearances or write me something or tell me something, do this, do that, and so forth. It was really an unprecedented amount. Some of this stuff has actually gone through. Some of it you regret, some of it you don't like, some of it you do like. But I think for the most part, it was interesting how bipartisan the situations were. Because from the Democratic side, they were seeing small farmers and small middle-class workers and lower middle-class blue-collar workers being bulldozed out of the way. And on the other side, you saw Republicans who actually care, at least some of them, not those in the White House, but some of them actually care about property rights and the sort of the larger allocated issues that we face. So this is essentially the way in which the sort of the Kelo thing has evolved on the takings issue and the public use issue. Let me just mention one other point, because I think it's extremely important, and if anyone wants to understand the takings clause as a whole entity, you cannot do it by simply looking at the public use side of the agenda. The single most important distinction in the takings law is that between a physical occupation on the one hand and a partial restriction on land use on the other, aka zoning as the paradigmatic case. The Supreme Court, in a burst of foolishness back in the 1920s, decided that you wipe out 80% of the value of land in a silly zoning project. You don't owe a dime in compensation, because there are always external benefits, none of which could have been identified in the particular case. So it's just a huge downward spiral. What now happens is as follows. Communities know for the most part that the level of discretion that you have in using zones or land use restrictions are very great. Once you do that, as I'm sure they did in New London, what you find out is that there's a lot of stagnation that takes place as lands cannot move from one use to another. Zoning, in effect, represents a very primitive view on how it is that land adjacencies matter. It comes from a skeptical point of view that unless all lands in the same zone have the same use, there are going to be immense conflicts. So all externalities between alternative uses are thought to be negative, when in fact many of them are positive, which is what Jane Jacobs proved in a great book about the death and fall and rise of great cities, whatever it was called in 1961. You have a zoning situation. Things start to go down. Now you've got to turn things around. No private developer is going to come in and fight you on the zoning. So what you do is, since you're screwed up on the zoning side by way of restriction, the only way you can unravel it is to have massive public condemnations on the other. So that what happens is, if you play the crazy restriction game, You drive yourself into dangerous conditions if you don't play it correctly. Some towns zone better than others, so it's not a those universal phenomenon. Then you do desperate measures. But it's always the following case. There's kinds of people who screw up on the one and are not going to do it right on the second. And what you really want to do for the most part, if you're thinking about how you get adaptive changes, is you want to relax all of the zoning restrictions so as to allow for a greater level of mixed uses. And essentially concentrate your efforts to stop those things that look pretty close to common law nuisances, which of course was exactly the test that they rejected in the Euclid case when they announced very unceremoniously that everybody knows that people who live in apartment houses are parasites on the single-family homes that are nearby. Where the word parasite is not my word. It's just a Sutherland's word, right? I'm not mistaken. So, I mean, it's kind of scary. And so what you have to do is to be much more holistic in this and understand that you can't fully appreciate the consequences of one portion of the takings doctrine unless you look at the whole piece. And in my book, in effect, on the takings, what I tried to do was to explain why every part of the puzzle was misshapen. And if you put them back into correct situation, you could overcome every serious holdout problem, every collective action problem, every common pool problem, without putting yourself into the position where massive destruction would take place through misguided efforts of redistribution. And you want to watch what's happened, look at Kelo. These people have spent $73 million on infrastructure. I don't think they've built a thing yet. 80 million by the time they got done. And the irony in the Kelo case is after they wasted all this money, which they got from a crooked state appropriation, or a dubious state appropriation, they may not have enough money in the Treasury to actually pay for the houses that they wanted to condemn from Ms. Kelo and her friends. And at that happy note, we end this great saga in the American land planning situation. It really is, no matter what your political views, a kind of a public travesty, which we hope will never be repeated, whether or not we remain in the big planning state in the foreseeable future, as seems likely, because, to put it mildly, the property rights movement does not fare very well in the last 5 years in the United States. Thank you.
Questions. I have a sign-up list for the Castle Coalition, which is the Institute for Justice's group that they started to fight eminent domain abuse, and stickers and pamphlets. So if you're interested in signing up and learning more about these issues, I have some sign sheets and stickers and brochures. And I guess we have a little over 15 minutes for questions.
Yeah, let me make one observation. One of my colleagues came up to me after the case. And he saw this and says, "What's the Castle Coalition?" I said, "Think, Jim. My home is my castle." It finally became clear. One of the great remarks that Tom Merrill, who wrote a brief on the other side, told the speaker for the planning, he says, the problem with all this stuff about Kelo, because he can't understand the reaction, is that people actually take private property seriously. They're actually invested in the institution. They have families, they have homes, they have farms, they have businesses, and they really ought to be much more indifferent to their fate. And I think that academics have so much talked themselves into thinking of property, some abstract bundle of rights, that they don't believe that for ordinary people who, by the sweat of their brow, to use a biblical and Lockean image, folks, I can with you, Jacobson, I can't mess around, that they actually feel invested in the things that they own. And they do. And when the rights are fully offended, what happens is all of a sudden they lash out in strange and unpredictable ways. And one of the greatest things that you have to remember is a lawsuit. And there's a law. If you can't talk to ordinary people in the language that they talk to each other, you can't do your job. It's not a question of not believing in the abstract stuff, which I spent so much time on. But what you have to be able to do when you make one of these fancy arguments is to understand how it plays out on the ground. So that when you actually explain to people why it is that they have to learn the terminology that you use, they will relate it to their own sets of goals and aspirations. If you can't do that, you cannot argue, because you will have no emotive hold over anybody with whom you deal. And you really want to lose an argument, just get a pure rational choice type to argue about any issue in front of any ordinary member of the public. I will tell you one little story about this in another question. It's a story I tell all the time. I was going to a Liberty Fund conference one day, and I was trying to explain how it is that a classical liberal in economic training looks when they talk about property rights. And I went on about some of the things that I was talking here. And there was this English professor who heard this, and he said as follows. He said, Professor Epstein, I don't think I understood the fine points of your arguments, but there's one thing I'm perfectly sure of. I said, if I could play this tape before any jury in any jurisdiction in the United States, I could get you civilly committed. How far removed he thought I was in my speech from the aspirations of ordinary individuals. And then I tried to explain to him, no, actually, it ties up much better. And what I call bilateral monopoly, you call fair is fair, let's split it, all the rest of the stuff. And that for every fine, learned, economic conception that I rely on is an ordinary language equivalent to it, which is meant in common language to essentially supply the same answer. So I think you can meet the challenge. But if you're not aware of that translation function, then you belong in an economics department. As a law school, you must be aware of the rhetorical issues, or otherwise you will just kill yourself. Ronald Reagan was the master of that, in the good sense of that term, right? And George Bush? Next question. Questions? Anybody? Yes, in the back. No, you, sir. Yeah.
The Wall Street Journal published an article about 2 weeks ago about the city of Anaheim, and how they've taken a section of their downtown and eliminated all zoning restrictions. Are you aware of similar projects elsewhere in the country?
There was one in Houston years ago, and I'm not aware of it, but I assume that there is Anaheim is going on some hard times, I would assume.
That's what I gathered from the article.
What they would do it, and what they're trying to do in effect is to let sort of ordinary synergies take their hold, reduce the cost of coming in, and hope that that will replace direct public subsidies. And there's a very important lesson in that. Once you start playing zoning restrictions, a building code restriction, and you realize there's too little building, what you then do is you tax somebody in order to subsidize, right? The problem about a tax is that it's an excess burden on somebody else. So it doesn't get rid of the problem, it just shifts it from one guy to another guy and creates this huge political ruckus as to who's the payor and who's the payee. The advantage of removing a zoning restriction is it doesn't cost money to anybody, and it reduces costs, and so therefore will increase activity. And so generally speaking, you always want to move in that direction. I would say somewhere up of 90% of most zoning restrictions are perverse or wasteful. There are very few of them that actually make sense. What you really need to do is to have a body of law such that if somebody builds something which is a real pollution factory and it makes noise and motors, you shut them down regardless of the cost of putting it there. And you're really tough on them in the ex-post world because you want to make sure in the ex-ante world they don't do these kinds of crazy things. And that's a very effective strategy which is a lot cheaper than all this constant effort to sort of plan what you think is going to be an optimal adjacency to something else. The unexpected synergies that you can get from cooperation between neighbors in a district with different uses are what is blocked by zoning, and this should help to achieve it. So, I mean, I'm in favor of these kinds of experiments. I am not in favor of a so-called laissez-faire system where I can do whatever I want with my land no matter what it does to your land. But there have been rules from the law of nuisance which are designed to deal with these adjacencies. And there are covenants that you can have through common unit development which can help ease the problem as well. Rely primarily on those two devices, and zoning is a relatively restricted activity which is used for macro and for nothing else. So that's fair. Yes, my dear?
How do you respond to advocates of planning and zoning who point
With
out
pleasure.
who point out cities like Houston that are not walkable? They have a lot of aesthetic problems. They just, in general, are not as livable in a lot of ways as East Coast cities that seem to be more in the thing. My understanding of Houston was unzoned.
It was, and it is, in fact, I don't think it's necessarily the non-zoning that takes place. One of the things that happens is you're going to do better in an unzoned city where you have a common owner who can, in fact, create a common plan so as to internalize the externalities. And so what you want to know when you watch these particular cities evolve is exactly what was the initial system of property rights and the distribution before any construction takes place, because non-cooperative behavior by separate landowners can lead to trouble. That's the first thing you'd want to know. The second thing you'd want to know is, okay, they didn't have zoning. Did they have any other kind of regulations that were, right? And what kind of distortions would these have? The system of taxation, the hookups on infrastructure and so forth. Did they have any kind of height, shape, or volume restrictions going on there or not? You've got to know the full picture because there may have been some other regulatory influence. That's the second one. I don't know the answer to that one, but it strikes me. The third question is, New York City is its own city. And there are parts of New York City which have exactly the same features as does Houston. In fact, it was New York City and these sort of cavernous buildings where there's no life going on at night, which was the exact source of criticism that Jane Jacobs read when she wrote a book on cities back in 1961. So if you're going to try and compare, you don't want to let the anti-Houston crowd say, oh, this is less than optimal, and then assume somehow or other if you put zoning in there, you get yourself back to some level of optimality without any clear conception of how it is that you're going to be able to do that. So essentially the argument has to avoid the nirvana fallacy, where their system which is untried is perfect, your system which is tried is not. And so if you put all of those things together, what you can then do is then figure out, well, what is it that we can learn from this? And listen to what I said before. I said you start with a nuisance law, you go to a covenants law, and then only after those two have exhausted do you think about a zoning set of restrictions. And this is not meant to say, in effect, that there's no zoning that makes sense. What's the test for zoning making sense is the next question. You want the restrictions when imposed upon all owners to essentially improve the value of all the properties located in the area. And if it has radical differential effects, you want transfer payments so as to equalize the situation out. So at that point, the challenge then switches. All right, you think there's zoning. Show me a zoning which makes an aggregate improvement. If you can do that, we can arrange the transfer payments, and you win. If you can't do that, then forever hold your tongue. And at that point, it seems to me that you've got yourself a fair test. Is it an empty set? Is the next question. No, I mean, let me give you two kinds of zoning ordinances that I talked about in the Takings book, both of which work. One of them is signage. Oftentimes when it comes vertical into a street, has the annoying habit of blocking each other's, right? So nobody can see anything. You have an ordinance which requires all signs to be of a certain size and flush against the building, or only at a certain level. There's more visibility across the world. Everybody's better off, nobody's worse off because we've avoided a collective action problem, right? And then in some areas, like in Jerusalem or the New Carré, the exteriors of the building are harmonized in a powerful way. And so you require Jerusalem stone where you don't allow people to rip down facades. And what they did in the New Orleans thing was really very smart. They said, we want you to keep this old facade up. We know it's going to lower the value of your property a little bit for the benefit of neighbors. We're going to compensate you. How? By lowering the taxes that you have to pay in virtue of the fact that we've subjected you to the restrictions. And then when you cancel the two things out, you've got a Pareto superiority. So what I want to do is see that kind of zoning take place, because you can see why you have to have a zoning system. And therefore, when you go back to Houston, go back to the plan, show me what you want to do. And if it's good, I guarantee you we'll fit within the Pareto model. And at that point, we're agreed. But they don't want to do all of that stuff. They just want to say, here's a failure, so therefore zone under the current system. And I think that's just much too hasty of an argument to make, given all that I've been able to say. Are there any other student questions? Maybe do a question. I'm going to have to ask Ilya a question. I don't know why.
As you know, Richard, I'm sympathetic to your view that certain takings and zoning should be limited as much as possible to public goods and collective actions problems. But I do wonder if this is judicially administrable. It's like, you know, at GMU, I at least try to teach the students what a collective action problem is. I don't know if I succeed or not, but I at least try. But at the vast majority of law schools, or most of these judges go to, they don't do that. And so the judges probably don't know a collective action problem from a hole in the wall, and therefore, I don't know if they're capable of administering this.
Let me give you the following answer. One of the reasons why they don't know anything about this is because it's no longer relevant to what they do. You start telling judges from the Supreme Court that when you do this, you have to worry about administering externalities and collective action problems, and this is what we instruct you to do. All of a sudden, people will write briefs that will educate these slow-minded judges so they can figure out what's going on. Let me give you a concrete example. We have every kind of coordination problem amongst individuals when we're dealing with transactions amongst states. It is very clear that Justice Stevens, one of the few points to his credit, is committed to keeping an open free market across states. Now that would be very easy. All you wanted to do is to say no state boundaries. Unfortunately, states have to impose taxes. One of the things about this guy who can't figure out how to tie his shoelaces when it comes to a takings case is he's dead on the money when he's figuring out which taxes have disproportionate impact that adversely affect foreigners are not intended to overcome financing the collective action problem. So he gets it right. Why does he get it right? Because he cares about the outcome. And if you start looking at areas, this is the universal proposition of American constitutional law. The lower the standard of review, the dumber the judges. If you give them rational basis, They are willfully stupid because they don't have any reason to be smart. If you give them strict scrutiny, all of a sudden their IQ raises because they actually have to see whether or not this thing makes some kind of sense. And they start pushing. There is a great fallacy on this issue. One that is made all the time by the Holmesian dissenters or dissenters, which is, we're not smart enough to do this by ourselves. We don't have any expertise in it. That's absolutely right. I'm not asking you to sit on a planning board and put the damn thing together. I'm asking you to sit on a court and after it comes forward to evaluate the work. And you know what? We do that in antitrust, we do it in patents. These areas are at least as complicated as some. You can do it here. Rely on good evidence by public officials who now are going to present a decent case. Why are they going to present a decent case? Because they know if they don't, they're going to get their heads handed to them. And it will change the projects they do, and it will change the defenses that they give. So that never has troubled me in the slightest. I mean, one of my friends, one of my former students, Lee Rosenthal, who's a very good judge on the district court in Texas, says, why does everybody assume that I'm a dummy when it suits their political convenience? I mean, she was genuinely resentful. My attitude is, you were an A student. I think you could figure this stuff out. Maybe you can't invent it, but that's not your job as a judge. You got very expensive tutors who are willing to educate you. You'll listen to them both and you figure it out. And so the briefs would change, the whole stuff would change. This law school would become much more important in the grand galaxy, given the fact that what you teach now actually matters in the way in which people run stuff. I think we have time for one more question. Well, there's got to be one. I will be disappointed. I will tell you a dean. Who had the question? You. No! Am I going to have to say that I count you all to submit? Thank you. Your question, yes, sir.
Do you think Kelo will be overturned?
Who?
Kelo.
Oh, Kelo. Let's put it this way. This is the great thing. We've lost two justices, right? But they were both in the dissent anyhow, so there's no short-term flip on the matter. I think the answer is only if there is another sort of sensible kind of conservative appointment. I think it would. I think that the response would take place. This depends on the political election. One of the things I think which is not likely to happen is for Justice Stevens or any on the other side to flip over. Maybe Kennedy. But here's the other problem that you have to face with this stuff. The Supreme Court really believes that relaxation for its older judges is very important. They take 80 cases a year. And so, think of the sequence. We took a takings case in 1954 on public use. We took one in 1984. We take one in 2005. So yes, we may take another one in 2026, right? The real question is, will this thing ever get back there again in a way that they will want to look at? If you look at every single property case they have, the ones that term, San Remo, Ling, not Palo Zolo, Lake Tahoe, Monterey, all of them are homilies to the planet, right? And unless you get a change in basic attitude, the current liberal majority will in fact dominate. So you're going to need to have at least one more Bush appointment, and it can't be Harry Potter. All right? I mean, I think our time has come to the appointed hour. By the way, if you look at the clock, you will realize what is wrong with the George Mason Law School. It is that the 6 hand is past the hour when the minute hand is yet to reach it. Right? That means that all is not well in the state of Virginia. Thank you so much.
Please sign up on the sheet, or if you want brochures or stickers, I have those as well.